right, let's start it off. I still see some joining. It's a pleasure to be here with you all today. My name is Chaz Tedesco. I'm the Chief Operating Officer here at Call Tools, the world's leading cloud contact center platform. Thank you all for joining us for the Future of Call Center Regulations webinar. A simple disclaimer I have for everybody: all materials discussed during this event do not constitute legal advice. Any material contained in this presentation should be validated by an attorney. And I happen to know the best in the industry. It's an honor and a privilege to be hosting this event today alongside Troutman, a mean firm, and with the TCPA czar himself, Eric Troutman. Eric, it's a pleasure to have you here today.
Absolutely. Fun to be here.
Awesome. Awesome. Well, as you guys can tell from the title of our event, we're looking into the future. We're looking at the ever-changing landscape of regulation, TCPA, and things that are going on in the industry. And Eric is extremely knowledgeable, probably one of the point people to go to for any of this information. Eric, it's a pleasure to have you, like I said earlier. And with so many changes happening in the industry, what's the best way for companies to keep up and maintain their compliance?
Well, the best way to keep up is obviously to follow tcpaworld.com, which is, of course, my website. We break down every single case, every development, every single day. tcpaworld.com, totally free, no barriers. You don't have to sign up to get the content. You just go in there and get free information. That's the best way, obviously, to stay informed. But beyond that, you really need to have counsel. You really need to be paying attention to developments. You have to take this stuff, really seriously, because as we're going to talk about here in a second, there's a lot going on right now, and in the future, there's a lot going on kind of as we look directionally to where we're headed. Obviously you guys want to do things the right way. So stay tuned, take it seriously, pay attention, and turn to the good free resources like tcpaworld.com when you can.
Awesome. Yeah, no, we're big fans over here at Call Tools. I think not all of our staff are followers, and we try and keep up with, all the developments that you guys are sharing. So definitely our go-to for all this types of news. So, I saw recently in one of your podcasts, we're seeing state-specific regulations coming about. I think more and more. And specifically, I think you were talking about Florida, where they were, beginning to put some things in place to limit contact attempts within a certain day. So I guess maybe let's start with Florida and kind of what you see happening in terms of some of these state-specific regulations that are coming about.
Yeah, no, it makes a lot of sense. So when we're looking at the future of call center regulation, we obviously need to take into account the past and the present so that we can understand how to kind of guide ourselves. In the past, right, most of the regulation you'd have to be worried about as a call center was at the federal level. If the U.S. Congress was doing something, or the FTC or the FCC was doing something, you need to pay very close attention, and you still do. We'll get to that. But the states were very, pretty inactive. You'd get a couple of DOJs or an AG here or there that wants to go rogue and kind of do things their own way at the state level. But for the most part, there really wasn't very many actions brought. There wasn't really too much for you to worry about. But that's changing. And that's likely in response to the Supreme Court decision in the Facebook case, which, the popular myth, at least, is that it makes it so that auto dialers are a very thin definition or very narrow definition. And whether that's true or not, what we can talk about. But the state legislatures thought it was true. And so they responded because they were afraid, hey, look, the feds have basically stepped out of the game. They're no longer regulating auto dialers. They're no longer regulating robocalls. Not true, but that was a perception. And so the states wanted to step in. And as a result, there's been a series of brand new laws that have come out. One of them was, of course, in Florida. Ironically, the Florida bill, this is how fast things move, right? Came out, expanded the reach of the statute, and then within a year, the legislature was like, "Whoa, this is too much. Too many lawsuits are being filed." So then they went and constricted it again. But let's look at Florida real quick as a blueprint. What they had originally was an extremely broad definition of auto dialer that would include any system that automatically dials or determines the sequence in which numbers are to be dialed, which is basically any workflow tool that any call center is going to use, right? Everything was instantly an auto dialer, even if at the federal level it wasn't an auto dialer.
Right.
Additionally, the Florida rules took away any EBR defense. There was no established business relationship defense. And as you were pointing out, it limited the number of call attempts you could make to just three. And it also, and that's not always, but per day, 3 per day.
Gotcha.
It also cut off your contact window at 8 p.m. instead of at 9 p.m. And that's looking at the specific called party's zip code. And there was very, very serious fines that are assessed under the Florida Act. Now, as I mentioned, that's been amended. All right, the genie's been put back in the bottle to a certain degree. Now you've got a 15-day grace period where somebody has to say stop to a text message, for instance, and then you'd have to continue to text them on the 16th day in order to get sued in a class action under the text provision in Florida. So that's a big deal. It's very helpful for callers, and took Florida from probably the most aggressive anti-robocall and anti-robocall text state in the country to maybe the least aggressive anti-robotext in the country. However, Florida is just one state. We know Oklahoma has adopted pretty much a duplicate of the original Florida bill. So that scary Florida bill I was telling you about that became law but was redacted, but was amended. That is currently the law right now in Oklahoma. States like Washington and California have very strict anti-text rules where if you don't have consent to send a text message, you can't send it no matter what platform you're using. States like Connecticut, Virginia have very, very strict disclosure rules. So you have to provide the first and last name of the agent that's contacting you, including when you're sending a text message. And New York and New Jersey also have some really interesting disclosure rules regarding what you have to say, when you have to invite a consumer to make use of your DNC list, and what even some magic language that has to be in your scripting. So a lot going on now at the state level. Again, 2-3 years ago, you never would have seen this, right? So that's the present. So when we look into the future, I think it is fair to assume that there's going to be a continued rollout, proliferation of these state level regulations. Again, it's very challenging to know exactly what state is going to adopt what paradigm, but we can imagine these are going to start falling into buckets, right? The Florida, Oklahoma type rule, I think we can expect to see that one rear its ugly head again elsewhere. And the disclosure rules that we're talking about in Connecticut and Virginia, we can expect those to be duplicated. And even the anti-text complete ban on non-consented text that we see in in Washington and California, we can expect that to take, maybe spread some as well. So when you start looking into the future, you have to be thinking, all right, obviously I need a technology platform solution that can help me, make sure my cadences are correct. I'm not calling more than I can. I'm obeying all the various limits that have to be obeyed. Maybe there's some scripting that a platform can assist me with in certain states where disclosures are required, because we're going to see more of this, not less of this. And obviously you want to pay attention by following tcpaworld.com, but you also want and now I'm saying Chaz and Call Tools to be paying attention and integrating whatever rules they can. I know you guys do this. You're very on top of it, which is why I'm happy to be on this program. Integrate whatever rules you can and build them into the platform to take the heavy lifting off of the user of the platform, and the platform user can use this and safely assume that the Florida rule or the Oklahoma rule is not going to be violated, as an example. So that's the first thing we should talk about. We have just covered it now, is that state level regulations are going to continue to proliferate.
Sure. And in terms of these, it's so interesting to see the landscape changing. Personally, I've been in the industry for, oh my God, maybe like 10 years now, a decade, right? And just seeing what it was when I first got started, had no idea. I mean, I was so naive. I was thinking back, when I was first creating a call center, I'm like, people still answer the phone, and then to come this far along and be in the industry for this long, it's just crazy to see just in that span how wildly different things are looking, right? So I think the state specific topic is really interesting. And thank you for covering it. You covered it incredibly here. How do you see it holding up, when there are these certain state specific cases? And then you just said in Florida, they redacted a lot of what they put out there. So they're not only pushing these things out extremely quickly, but it seems like they're also redacting or changing them. So how do you see things holding up within these states?
Yeah, no, I think that's fair. I think we're going to see this kind of the trend of, everyone's trying to level set right now. We're in a historic time when it comes to telecom law in this country. And it's true at the federal level, which we're going to talk about here in a second as well. But the state level, that's plainly what's going on, right? Like imagine that you've never taken a shower before and you turn the shower handle and it's blazing hot and you're like, oh my God, right? Well, I mean, look, obviously we've all taken showers, so we know how these things work. But the legislatures in these states, they've never done this before. They don't know how it works, right? So they just turn the handle and in Florida, they turn it to 1 billion degrees, right? And they're like, whoa, this is way too hot. Right. So now they're going to turn it down and maybe it'll be a little too cold. And the various states are going to be kind of doing the same thing. They're going to be turning that handle. They're going to try to find that right temperature. And it's going to take a while. I mean, that's just the bottom line. It's going to take a while. And these states are going to have to figure things out for themselves. And unfortunately, all of us in the call center world, right? All of us in TCPA world, as we like to say, I mean, we're going to be getting jerked around. We're going to be getting the boiling hot water. We're going to be getting the freezing cold water. We're going to be getting sometimes, you can't even tell what temperature the water is because it's not even clear. You're not even able to get in. It's running down the tube. You can't even tell because it's impossible to know what the standards even are. And to me, that's the most dangerous thing, right? I mean, you tell me you can only call 3 times in 24 hours. That sounds like a stupid policy, but at least it's a clear policy, right? At least you know what the rule is, right? I have a lot more concern with these state legislatures that really don't know what they're doing, and they use these really weird language like reasonable or aggravating or harassing or inappropriate or misleading or inaccurate. Like, what exactly do these words mean? And you find out only after the fact, right? When there's case law, or like in Florida, another great example is you have to be able to call back the number that calls you, and people are saying, well, look, if you send a short code text message, you can't call that short code back, so that's a violation of the law. Now that sounds ridiculous, but if you read the statute, they might be right. Right. And we're not going to know. And for the record, they're not right. It's a terrible argument. But my point is, it's a straight-faced argument, and the courts have to weigh in on a lot of these terms in order to give kind of the guidance that people need. So you're right. Things are moving incredibly quickly. They're moving quickly at the legislative level. Understand they're going to continue to move quickly at the decisional, that means the case law level, right? As judges weigh in and rule on what these things mean. And everyone's trying to figure this out for the first time. And that's obviously a recipe for a lot of challenge, if not a recipe for disaster.
Sure. Yeah, I mean, I think it's very interesting too. Like you said, keeping up with it in the education is important. Having a solution that has the features to help making, controlling these different ever-changing rules and regulations is super important, like we do here at Call Tools. But it's very, like you said, concerning that things are changing so fast, that you might blink, and if you're not paying attention for a week, 2 weeks, something went into a bill, got passed, something changed in the state that you're operating in. Now you've got a letter, and you're having to, move forward with something that has happened, that just was recently put into place. And at what point does plausible deniability take effect? That it doesn't, right? I mean, there's really no way for you to say, oh, I didn't know this was happening, therefore, I didn't do it. I didn't know. You didn't tell me the rules. So I think it's very concerning.
And I say this with love, right? But if you're in the call center game, if you're in the TCPA world, if you're in the telecom world, you need to understand, again, we're in historic times right now, right? We're at war in a weird way.
Yeah.
The regulators, the legislature, they are at war with this thing called a robocall. Right. And they can't distinguish, the fighters. They can't tell who's the good robocall and who's the good call center and who's the bad one. Right. Y'all look alike to them. And that's not a good thing because they're out here carpet bombing everybody. Right. And so, just understand that if you're in this game right now today, you're in historic time, you're in a battlefield, the crosshairs are on you, whether you like it or not, whether you feel like it's fair or not. And it's not fair. But in this game, fair ain't got nothing to do with anything, right? So the only thing you can do is protect yourself, right? Is to really make sure that you understand it matters. It matters. The law matters. The regulations matter. And you and your company and even you personally can be held liable if you are violating these laws, which, again, I get it. They move quick. As I just told you, some of them aren't even clear. We don't even know what the law is in some states, in some circumstances. And it's terrible. And yes, there's constitutional arguments, there's due process arguments, there's things that can be made. But really, the answer truly has to be, you have to be conservative. You have to be thoughtful and conservative. Get yourself good counsel, find somebody that can help you to understand the difference between the red light, the yellow light, and the green light, right? And make sure that you just, again, it's just a mindset game, right? What I find with people is once they wrap their head around the fact that they are in a highly regulated industry, that they are being looked at and scrutinized, but that they can survive. You can survive in this industry if you take this stuff seriously. I feel like it really helps people to be able to engage with the compliance process and do things the right way. Although, and then other times I find that people will sometimes shut down if they're like, either I don't care and I'm just going to go, or it's just so overwhelming I give up, right? Neither one of those mindsets is good, right? The right mindset is, the healthy mindset is, this is a heavy regulated game. There's a lot of money to be made here, right? But there's challenges, there's difficulties, and I'm going to have the right mindset. I'm going to try to do it the right way, follow the law, and then you can still be successful even in this very tough marketing environment.
Sure. I have one question here from the chat, and thank you all for being here. Feel free to enter our chat at any point. We'll probably have some time at the very end to really address some crowd questions. But I think this was a good one that came in from Troy. He said, did you say Washington, California, Virginia, and Connecticut require consent to text? How about to call? Is it different than in the other 6 or so wireless no-call states? So I think this goes back to what you were saying a little bit previously.
Yeah, so in Washington and in California, those 2 states specifically, it is literally illegal to send a text message using any platform for any commercial purpose unless you have consent. That is not the case in any other state that I'm aware of. However, again, can't give you comprehensive legal advice on a webinar, guys. If you need help with these things specifically, and you probably do, you should reach out to us, right? Troutman Amin, LLP, Pooja Amin, and our paralegal Angelica have a tremendous number of resources to help you on a state-by-state basis. But yes, these are all different, Troy. There are, no-fly zones, so to speak, no outbounding for folks, particularly on DNC lists. There is no, to my knowledge, state that prohibits any outbound calling to a number that's not on the DNC list, unless you're using certain technology. But California and Washington are unique because they do, in fact, ban text messaging for commercial purposes without consent. It's a very strange thing. But again, there are 50 states and 49 of them, not Iowa. All the rest of the states other than Iowa have some form of an enactment here. And so you need to be aware of these things. No question about it.
Sure. And I think, in regards to the text messaging and SMS space, I know that one's gotten really, stringent through the last couple of years. Again, now we're talking state specific. So my questions kind of have to be a little bit, floating around, but I know that a lot of the states now are requiring a double opt-in for the SMS, meaning that they have the proper language, right? This is my understanding. Maybe correct me if I'm going in the wrong direction. They have to opt in with the proper language through the proper channels, then receive the initial text message, and then reply back, yes, I further give you permission to now text me.
I'm not aware of any state that is. I'm not aware of any state that has required MFA of that sort. However, I am aware that the CTIA guidelines and best practices require that secondary opt-in for all marketing campaigns. Now, that's not the law. And truthfully, I've had about enough of the CTIA and the wireless carriers trying to dictate how things are done in this country. But that's a topic for another day. But that is actually a topic for this day as well, because the future of call centers, as we look at it, the regulations, are not just regulations at the state or federal level, or even at the local level, by governmental officials, but also by the carriers themselves who, either lawfully or in all likelihood unlawfully have taken the power to both label and ultimately block your communications with your customers. Now, I have a very serious problem with this from a constitutional standpoint, but regardless, this is what's happening right now. And so even if you can comply with the law, which as we've talked about is quite the challenge, and we're only talking about the state level, we haven't gotten to the federal yet, buckle up for that one. Even if you can comply with the law, you still have to deal with the carriers now who decide, oh, you're perfectly lawful, perfectly consented, perfectly properly sent communication. I'm just going to go ahead and block that. And, again, I think there's remedies there. I think, somebody ought to be suing these guys, and I'm looking forward to the opportunity to bring these lawsuits. But that is just something to keep in mind. I think, and this is just me looking at my crystal ball. In the regulatory landscape, I'm expecting more regulation. In the carrier landscape, I'd like to think we've reached the zenith of the carrier's bad behavior, I'd like to think that there won't be more extreme blocking and labeling than we see today. I'd like to think that this is it. This is the highest blocking regime we're ever going to see. Knock on wood, I'm right. We'll see.
Yeah.
But I'm expecting litigation any day, truthfully. And once the carriers start getting sued, I think they're going to knock it off. That's my view.
Yeah, this is something that, I've seen as a huge topic, at trade shows with people I've spoken with in the industry about the calls being blocked. And, on an extreme level, my example has always been, you have certain people that are, calling, maybe they're using their cell phone to make phone calls to their customers, and they use their cell phone very heavily. I've seen in the past where cell phone calls get blocked, so a personal cell phone doesn't go through. And I'm just wondering at what point, like I said, if you're opting in, and this is my personal standpoint, on your phone to say, listen, I want to turn on advanced blocking and stop, any type of calls from coming in, you're opting in as the consumer. But, the fact that it's happening on the carrier level and you may never even receive that phone call or know it was placed to you, I think that's what you're kind of touching on here, is that I think that's at an extreme.
Yeah, I completely agree. I mean, when a consumer decides that they don't want to hear from anyone that's not on their contact list, cool, right? That's their decision, and they're going to miss certain messages that they probably would have wanted, but they've made that call, and that's fine, right? Personal accountability. We make these choices. That's okay. When the carriers, however, are on a default basis deciding that they know best what you want to hear and what you are going to hear, man, that is censorship, and that is a very dangerous thing. And technically, under the First Amendment, it's what's called a licensing scheme for a prior restraint on speech. Highly illegal. We don't allow that sort of thing in this country, and yet we are, right? Because again, we're at war, right? And when you're at war, you suspend certain civil liberties, and right now, the right to communicate, that First Amendment privilege that we all enjoy, we think, is definitely being whittled away at by the courts. I would love to see, some action. Like I said, I think we're going to see, some pretty good pushback here. But you're right. I mean, even we had Alex Felici, who is the CEO of Umail, very, very big app, call blocking app, was on our podcast, the Deserve to Win podcast, which you can find on Spotify and on YouTube. Go check it out. When he was on the Deserve to Win podcast, he was saying even his phone, the CEO of Umail, right, was getting labeled by the carriers because there were some high frequency calls that he was making, and they thought his personal cell phone was therefore spam. That's craziness. I mean, that's just nuts that this is the way we're living right now, but that's the state of affairs.
Have there been, in that landscape, like you said, you're waiting on the lawsuits to come in or something to happen there? Has there been anything yet in regards to the carrier activity, or is it kind of like uncharted territory at this point?
No, none have been filed yet. I think, the truth is, very few businesses want to stick their neck out. I mean, they figure, if 50% of my stuff is getting blocked, but 50% of my stuff is getting through, well, it's better to get 50% than zero. And if I sue them, I'm going to get zero, right? And so nobody wants to take that step forward to be the leader that we need right now to test these things. But it's possible that we do it on behalf of REACH, which of course is the Responsible Enterprises Against Consumer Harassment, that very important trade organization that helps the compliant actors in the lead generation and marketing industry to get together, share information, protect each other, and then advocate to the FCC and Congress. It's possible that REACH brings a claim against the carriers on behalf of its members. We haven't gotten there yet, but that's also possible.
Sure. And as that progresses, this is a really, one that our clients and people we speak with bring up all the time, because they're feeling it, right? They could be running completely compliant, all opt-in leads, very small, pool of leads they're trying to reach out to, and they're frustrated. I can't get calls through. I can't talk to my customers. I'm trying to call somebody who's an existing customer of mine, and they're telling me I'm showing up scam likely, and they're afraid to answer the phone call.
It's nuts. It's defamation, man. It's crazy.
It's insane. Yeah. So I think it's something that everyone's feeling right now. Like you said, on both fronts, there's a war that is definitely happening. And I think that everyone's fighting to see what is going to change. And what do you see as a good, when we do finally go down that path and the carriers get held accountable, where do you think the happy medium might lie in terms of, what is getting blocked, what's not getting blocked? Should they not block anything? I mean, some people have a theory that on either extreme, listen, the carrier shouldn't determine any call that goes through. They should let it go through. And then if the customer chooses, like we were speaking about earlier, to stop certain things or opt into certain technology that belongs to their phone, maybe that's where it needs to be. But where do you think the happy medium is going to come to?
Well, remember, for 80 years in this nation, the carriers were common carriers. They had no right to block. They had no right to throttle. If you want to pick up the phone to call your mom, they don't question that. They would have to go through. If you were a mob boss that wanted to call in a hit in New Jersey or something, right? The call went through. There was never, ever, ever an opportunity, and the carriers knew that they were not allowed to block anything. That's the law. Communications Act says that. It wasn't until 2015 that the FCC started giving the carriers the right to block, first on an opt-in basis. And then in 2018, they tried this thing called default call blocking. And then in subsequent orders, not only did the FCC say, yes, you can do it, they started saying you must do it. And now we live in a world where the carriers are terrified, because if they allow unlawful traffic onto their network, they could be shut down by the FCC. And that's something to keep in mind, is that the carriers are under tremendous pressure, right? They're not just doing this for the fun of it, although I think they do also do it for the fun of it. They're doing it because the FCC has put a lot of pressure on them. So where do I see it landing? Look, I think that using a private backstop of the carriers to stop illegal scam calls is valuable. I am not an advocate of going all the way back to the old days where it was common carriers. I'm an advocate of empowering the private sector to be a backstop to protect consumers and to back up the regulatory effort. But there needs to be clear standards. Currently, the standard is you can label whatever the hell you want, and you can block anything that you reasonably believe will be unwanted, not illegal, unwanted by network users. That's crazy. That's way too much discretion. There is absolutely no standard there. And as you can tell, the carriers are abusing this because, again, think about the incentive. Think about the incentive, right? If they don't block enough, they might get shut down. If they block too much, no one's suing them. So who cares, right? Now, again, they either start getting sued so that now there's a second piece of that equation. Currently, there's only one piece of the equation, which is fear of the FCC. There's nothing over here. Once they start getting sued, then there'll be fear on both sides. And I think we'll get to a middle point.
Sure.
Where I'd like that middle point to be, it's very straightforward. You can block illegal calls. That's it. Not unwanted calls, illegal calls. And I support that, right? If you're a scammer, if you're an IRS guy, or even if you're a cold caller that just wants to put 100,000 numbers on the DNC list onto a dialer and fire away, or RVM campaign, like, sorry, dude, get out of the network. And the carrier should be, and I would applaud their efforts to stop those kinds of calls. But they're just deciding that they're going to stop really truly consented legal calls just because their analytics say too many short duration calls, or they called too many times from this DID today and we don't like it. It's not acceptable. It's not acceptable.
Sure. Yeah, it's definitely something we see a lot of clients, people, businesses dealing with right now. And it's like you said, I think it's going to reach a point where it's going to start to level out. When is that going to be? I think we're all here for the ride, right? And we're going to see what happens in terms of some of this. So I do see some questions popping in here again. Let me grab one or two more, and then we'll continue. And I do want you did say we did do a really good overview of the state level. You said there's some stuff going on the federal level that we're looking forward to in the near future. So let's take one more, and I definitely want to jump into that piece of the conversation and see what we're seeing in our near future here.
Yeah, we definitely need to do that.
For sure. So let me see here. I had a good one I was just reading. Let's see. I guess one was Troy again. Are you and any other defense lawyers still having luck establishing a consent defense for clients who listed hundreds of firms who might be contacting the consumer? Does Call Tools plan to add human selection feature? Let's hold this one to the end, Troy. I'm not sure I'm fully understanding that one, but let's jump in. Let's jump into the federal piece.
Yep. I'm happy to answer those questions as well. So at the federal level, there's a couple things going on. First, Congress is likely to hold, this is breaking news, right? I have not discussed this publicly. Congress is likely to hold a robocall hearing this month or by the end of October. And there is momentum, I am told, for yet another potential amendment to the TCPA. This one might be favorable to defendants to some degree. So you have to kind of buckle up and wait to hear about that. There might be changes at the federal level to the statute itself, which we haven't seen since the Trace Act back in 2018. But the real developments that I want to talk about are at the FTC and at the FCC level. Hopefully all of you who are watching this that are in the marketing game know that the FTC just changed the rules dramatically. right? Again, for like the last 30 years, the FTC has not really done much in terms of enforcing what's called the telemarketing sales rules, the TSR. That's the body of law that actually governs how telemarketers go about their business. The FTC has largely just left it alone and basically said, unless you're committing real fraud, we don't really care about you. Well, that all changed on July 12th, the day that shall live in infamy, when they launched what's called the telemarketing sweep. And now 150 regular old, for the most part, regular old telemarketing outfits, not the big scammers, not the fraudsters, just regular old folks who were buying leads were shut down and penalized. And lead suppliers like Fluent in particular, but others, were also penalized and deemed to be, quote, consent farms. Folks that were just using dirty tricks and dark patterns to get consumers to give consent, that they didn't really understand what they were doing, that they were basically tricked into doing it, that they didn't understand all the different verticals that might be calling them, for how long they might be being called, and who were being tricked into providing their consent with fake incentives, like you'll get a $100 gift card that they could never really get, right? The FTC put a shutdown on all of that and held the call centers and the marketers who weren't even engaging in that behavior to be also liable for this conduct. And most importantly, so that's all very, very, very big news. And that's ongoing right now.
That's
today,
a lot.
Right now.
That's a lot of
It's
different
happening.
pieces there. Yeah.
Yeah, it's happening. We're going to talk about that some more. But the most important thing, that's not even the most important thing. The most important thing the FTC did was it also ruled for the first time ever that you cannot use a purchased consent as a consent if you're going to use a pre-recorded call. So you cannot sell a lead and you cannot buy a lead if you're going to use that lead for a pre-recorded marketing call. It is flat illegal. No third-party lead gen leading to a pre-recorded call is allowed under the TSR as of right now. Brand new ruling. They didn't publicize it. I'm the only one talking about it. Nobody else seems to even know about this thing. Massively important. I actually spoke at the open meeting for the FTC last week, and I was like, guys, this is crazy. You need to be more thoughtful here, because the lead generation industry is a superpower. As I told the FTC, it's a superpower of our economy. Very, very important. And when you start telling people that it's, third-party lead generation is illegal, then that is a very big thing. Like, you can't just sneak that into a LinkedIn post, right? That's a really big deal. So that's what's going on at the FTC level. We can unpackage that a little bit, but as you can tell, there's a lot going on. The FTC is coming down, swinging a machete right now at the industry, and it's really something to keep in mind.
Yeah, well, that's very interesting. And I did watch a previous, I think it was one of your podcasts where you were kind of touching on this topic. Crazy, seeing how they determine. So again, call me naive. I just thought pre-recorded voicemail was already something that, or pre-recorded messaging was already something that was illegal at large. So I'm learning something new today that.
Well, it's regulated, meaning you can't use it without consent. What the FTC just said is, but you can't even use it with consent.
Wow.
Right? Even if you have consent, but that consent you bought from someone else, it was transferred to you as a third-party consent, then you can't use pre-recorded calls. Example, let's say you are Wells Fargo, right? If the consumer goes on to wellsfargo.com and fills out a form, yes, you can use a pre-recorded call. If Wells Fargo buys a lead from LendingTree, now Wells Fargo cannot use a pre-recorded call, even if Wells Fargo was right there on the list, five lenders, Wells Fargo is one of them. Consumer wants to hear from Wells Fargo can pick up the phone and call manually or use an auto dialer, but they cannot use a pre-recorded call currently under the TSR. Now that's going to change under something called the FCC NPRM potentially, right? So again, all we're talking about right now is the FTC, that's the Federal Trade Commission, and the telemarketing sales rules, right? And that is, as I just told you, governs pre-recorded marketing calls, and that's it. So fairly low impact because that's just one channel, right? FCC, Federal Communications Commission, as the name implies, has the authority over all communications, not just pre-recorded calls. It's looking at something in what's called a notice of proposed rulemaking proceeding, where it's going to decide, is it going to apply the same rule that the FTC just adopted, but apply it to pre-recorded calls, artificial voice calls, auto-dialed calls, and importantly, to every call to a number on the DNC list. If the FCC holds that you cannot buy a record of consent to use any of those technologies or contact anybody on the DNC list, you are now going to be losing at least 50%, right, of the people that you could otherwise have reached out to by buying this record of consent.
Sure.
Now you cannot. So again, depending on how the FCC lands, and there's different possibilities here. We're talking about the future, so we're talking about some different possibilities. But in the worst case scenario, again, going to the Wells Fargo example, again, if a consumer goes onto wellsfargo.com, that's still okay. You can still make outbound calls. If, however, Wells Fargo buys that lead from LendingTree, they can't use a pre-recorded voice. They can't use an artificial voice. They can't use an auto dialer. And most importantly, if that number is on the national DNC list, they cannot call it, even if LendingTree has sold them the lead and Wells Fargo's name is on the disclosure.
This is a big deal, everybody. I mean, if you really understand what's being said here, this changes the landscape of a tremendous amount of industries. I mean, almost every industry, I think, is going to be impacted.
Yeah, it's massive, massive. Yeah.
Absolutely crazy. Yeah. Wow. Well, let's see how this progresses. When did you say that hearing was for the FCC?
So the FCC does not have a hearing. It's called an NPRM. The FCC will rule when it rules. Now, I will tell you that we are in the hot middle of the lobbying season right now. Reach, again, Responsible Enterprises Against Consumer Harassment, is taking the lead on behalf of the whole industry right now. We're in there. I just spoke with Commissioner Starks' office yesterday. I spoke with Commissioner Carr's office last week. We're speaking with the entire bureau that does the Consumer and Governmental Affairs Bureau that writes the rulings next week. We are pushing as hard as we can. I'm the president of Reach. We're pushing as hard as we can to try to save the industry, to get the commissioners to understand that, yes, there are abuses in the lead generation industry, and it's been terrible, and it's failed to self-regulate, and it's brought this upon itself, by the way. Like, part of me thinks if the industry gets shut down, I'm just gonna be like, look, y'all had your chance and you didn't get it done. But I'm here to try to save this industry because I've met a lot of people here. I believe there's really good people in this industry. And most importantly, I really do believe that the lead generation industry is good for the consumer and good for the American economy. And because I believe those things, I'm in there telling the commission, hey, look, I know that there's bad actors. I know that they've screwed up. I know that there's abuses, but don't shut the whole thing down. There's good people here.
Sure.
It's like the old story.
As with any industry, right? I mean, there's always going to be, the people who are doing things perfectly well, great, everything's good in the middle, and then the people that are blatantly, doing malpractice, right? So
yeah, and that's where we find ourselves. And unlike many industries, though, I mean, the FCC and the FTC and the government, in my opinion, have also failed. So I've thrown shade on the lead generation industry for failing to regulate itself. But I'm going to throw shade on the government as well, because they've actually also failed to regulate. They haven't really given any standards to this industry. And with that being the case, no surprise, the industry is engaging in race to the bottom tactics, right? They see, well, my competitor's doing X, so I'm going to do X minus 1. And then they see, oh, he's doing X minus 1, so I'm going to do X minus 2. And they just keep, lowering their standards to try to get market share, try to trick consumers, try to, drive volume, which is where money comes from in this industry. And as a result, you get what you have right now, which is just people running amok. So, my pitch to the commission is, yeah, they're running amok. They're like kids that got loose in the kitchen. But when that happens, like, you don't chop off their arms and legs because they stole the cookies. You move the cookie jar, right? Like, you have to be thoughtful about the response here. And so, right now there's tremendous pressure on the FCC from groups like the NCLC, Public Knowledge, 12 Democratic senators of the United States of America, and 28 AGs have all come to the FCC and said, you should align with the FTC and shut down all lead sales right now. And against that pretty big army, you basically got Eric Troutman in there. There's a couple other people, but it's basically me against the world right now saying, guys, hang on. Let's
For the record, there's no one else I'd rather have on this side, talking some sense. So we're in great hands here, everybody. We're in hands of greatness.
I do. The czar fights for you, and but help us, right? Like, help us. Join Reach. Go to reachmbc.com. That's MBC is Mutual Benefit Corporation. See how you can join the fight. We're not asking for money. We're asking for time and commitment and amplification of our message, right? We're asking for a commitment that people are going to be good actors, abide by high standards, that they want to live in a sustainable ecosystem in the future where they don't trick consumers. They're not selling fake leads. We're only getting nice, transparent leads. And that's the world we all need to live in, right? And in that world, there's less unwanted calls, there's less regulation, there's less carriers blocking our calls, and we can get to that nice, happy, moderate place where we all want to be in the market.
Beautiful. It sounds beautiful. I think we can get there. I don't think it's that far out of reach. I really don't. You know, I think there's a couple things that, you know, like you said, need to be addressed and changed. But to your point, I don't think that, you know, cutting the arms and legs off is going to be the answer. And I applaud you in taking that stand and moving this forward here. I have one that, you know, I've been holding on to from a little while ago as you were talking about pre-recorded messages. And I know it's a hot topic. It's something that's going on, you know, all over. It's expanding. How does AI play into pre-recorded messages as, you know, it's generating itself in real time? I always classified them as one and the same, you know, in my brain, but how is that showing its face in the legal, you know, terrain here?
Well, so there's not much litigation around it yet, but to me, it's a pretty straightforward concept. AI, if it's an AI text communication, right, then that's going to be an SMS. That's going to be covered by the SMS rules. If it's a voice channel communication, it's actually pretty interesting because there's a distinction in the law today between a pre-recorded voice and an artificial voice, right? So AI is definitely an artificial voice, no question about that. The question is it pre-recorded in the true sense of the word? Now, for some less sophisticated kind of waterfall prompt, you know, your standard machine learning applications, it probably is just a pre-recorded, it's just basically a more sophisticated avatar kind of scenario. But for your true large language model voice generator programs and prompts, sure, I don't think that's pre-recorded. I think it's going to be artificial voice. Right? Yeah. And that matters because the TSR covers pre-recorded voices. It does not cover artificial voices, which is very fascinating. So if you can demonstrate that your AI is truly generating in real time, right, the voice, it's artificial, it's going to be covered by the TCPA. The FCC is going to have jurisdiction over you. But you have a pretty good argument that the FTC does not. So what does that mean? What that means is you could buy a lead today, and use your advanced, you know, LLM technology to contact that lead. That's okay. Now, again, in the future, if the FCC adopts the FTC's view, then that would not.
And the definition changes of artificial voice, right?
It expands to include artificial voice. Because today, the only regulation around the TSR that bans the use of purchase leads is for pre-recorded calls, not artificial voice calls. But again, the FCC has broader jurisdiction, so you would also get artificial voice calls brought in. So that's just something to think about. But you are right conceptually. So that's, you know, that's the deep dive. At a high level, you are right to conceptually think of AI technology as regulated technology that you're going to have consent for.
Sure. Yeah. And again, in my brain, I always look at the most aggressive, you know, how can, you know, what is the most compliant, broadest definition of everything? So I've just said in my mental capacity, okay, it's a pre-recorded voice. Like you said, the definition very wildly changes and it should be treated as such, you know, and that's kind of where my brain is at. But no, thank you for drawing some clarity. That's something new to me to look at how that's classified currently. So yeah, this lead generation terrain this is insane, you know, what you're sharing here on the federal level. And you know, what's your personal take on this? I know you're defending this, you know, on a certain regard in terms of, hey, slow down, guys, let's look at this again. Let's see what's going to happen here. In terms of when you said that there was a bunch of, you know, call centers that have been come down on, have they been shut down or have they have legal, really? So they've all been shut, you know?
Some have been shut down completely. Some have consent orders that limit what they can do.
Sure.
Same thing for platforms, same thing for carriers. You know, everyone in this ecosystem is at risk right now, no matter where you sit. Ironically, you know, the lead sellers are the ones that are getting the least attacked right now by the FTC because they sit, you know, they just enjoy this insulated, you know, area where, you know, the guys on the front lines getting hammered are the callers, right? The guys that buy the leads, right. The platforms, right? That, you know, that are being used to send the messaging, and then the carriers, the ones that are carrying the messaging. But ironically, the root problem, right? The guys that are causing all the trouble are the ones, the publishers and these ridiculous networks that don't have any standards and just sell junk after junk after junk. And they're the ones that are getting away with it, right? And so that's what reach is all about, is to shut that whole concept down. When I'm meeting with the FCC, what I'm telling them is, we've got to get away from blaming essentially innocent actors, right? If you're Wells Fargo, you've bought a lead, you want to talk to a real consumer, you're paying value for it.
That's your expectation.
Yeah, I mean, you're trying to talk to a real person that really wants to hear from you. That's what you're paying for.
Right.
But when Wells Fargo is being sold a fake lead because somebody upstream lied, concocted something, it was a click farm, used a bot, used a dark pattern, whatever it is, to get that lead in, and they get sold 6 times, right? Here's Wells Fargo getting something in real time, speed the lead, they're calling it immediately. They have no idea that this is a fake lead. They think it's real, right? They think it's real. Yet who's at risk? Who's in trouble for that call? Wells Fargo is, right? The guys down the upstream, they walk away. They walk away. It's ridiculous. And so that's what I'm trying to get the FCC to understand, is we've got to change the incentives. We've got to make it so that the lead seller feels the heat, that everybody in the chain is being responsible, not just on a contractual indemnity provision, because let's be honest, right, these things are not enforced that widely. We need them directly liable to the consumer. And people forget sometimes, right? Because for the most part, they see me at these shows, they know I work for the industry, and that's true, I do. But ultimately, right, I'm on the side, 1, of truth, 2, of stopping unwanted calls and protecting consumers, and 3, never forget this, most of my clients are lead buyers, right? I want the lead buyers safe. And when I'm looking at a world where the lead buyers have all the risk and the lead sellers, who are the ones causing the problem, have no risk, you better believe I'm going to be talking till I'm blue in the face to shift that, to get those lead sellers to be liable for what they're doing as well.
Wow. Yeah. And I think this greatly has to do too, and this is another, I guess, subtopic of what we're talking about with co-reg, right? Co-registration, opting in for, a sweepstakes, so to speak, but that's giving, 50 different companies across 20 different industries the ability to call that lead because they thought that they were, signing up for the sweepstakes to win $100. And in the fine print, it's like a Bible of all these companies can now call you, text you. So I'm guessing that is a huge contributor to this problem. And I'm not sure, has that been addressed at any recent point, this co-reg path of?
Yeah, it's being addressed right now. The FTC, that was a big part of the telemarketing suite. They came down hard on co-reg, came down very hard on it. The FCC is basically on record saying multi-vertical consents are illegal. The NPRM, one of the things that they're looking at is also whether or not to shut down more formally all multi-vertical consents. The idea of a co-reg, prize sweepstakes offering is front and center in front of both the FTC and the FCC. They are hated, they are disdained, and I'll tell you from a reach standpoint, our standards don't permit them. So I mean, that to me, it looks like that's going to be on the chopping block. Again, I'm the only one out there talking on behalf of industry, that I'm aware of. And I think I'd be aware. And I'm not carrying the water of any sweepstakes website. And with nobody out there protecting them, and that looks like something that's going to be jettisoned, right? Again, we're talking about the future. I'm going to guess, a year from now, no matter how everything else lands, that piece is going to be gone.
Yeah, and to my, surprised that it's even been allowed to operate at this level for as long as it has. That's one piece of it that I think is, blatantly contributing to a large portion of this, problem that we're seeing. So I'd be happy. That's one that I'd be happy to see kind of get shut down and kind of further regulated in terms of what we're talking about here. So
yeah, we could have a beautiful world, man, where, in the future, people go onto a website because they want to know about mortgage loans. Sure. And they get connected with people that just call them about mortgage loans. It's just a couple of people, and that's all they get. And they only hear from a couple of companies that they want to hear from. Sure. And then they go to an insurance website and they only get calls regarding insurance website. Like, that's the future. I mean, that should have been what it was the whole time. I mean, it's just common sense, But again, people want to engage in bad conduct, and when that happens, it's going to bring the regulators to the door. And ultimately, let's be honest, a lot of this is companies want to go public. And once you go public, what do you have to do? You have to grow, right? And how do you grow? How do you grow in a marketplace where, there's just not that many consumers that want to go to your specific comparative website, right? Yep. And you grow by a bunch of dirty tricks and adding in, peppering the steak and getting multiple data sets. And maybe, these aren't all legal. Now, again, I'm not blaming any particular company out there. I think that in my view, many companies in the lead generation industry have misbehaved. And it's not, sadly, this is not an industry where it's a few bad actors. Sadly, in my opinion, it's cultural in this industry. They just think it's okay, and everybody else does it, so they're going to do it. And there are few companies that are trying to do it the right way. And I literally, I was using the allusion to Sodom and Gomorrah and the old story of Lot being sent in, and if you can find me 50 good people, I'll spare the city. All right, if you can find me 25, if you can find me 10, and finally it's like, if you find me 1, I'll spare the city. I think I've got 1. I think, no, in seriousness, but I mean, really, I really feel like that sometimes. Like, I'm out here fighting the fight for the good actors, but there's so few ultimately in comparison to the bad actors, and really, I shouldn't be so stark. It's not black or white. And that's the other tricky thing. A lot of players are mostly white hats, but, they slip over here a little bit. Or they're mostly trying to follow the law, but, it's really hard. So I'll just go ahead and ignore this piece of it, right? There are, of course, true bad actors that just don't care. But, for the most part, most of these actors fall somewhere between white and gray, and sometimes a little dark gray. And we just need to get people over here lined up, set standards that business will follow. And the nice thing is I really do believe, and again, I wouldn't be fighting this fight if I didn't believe it, that the majority of businesses, if you give them clear rules, give them clear standards, give them clear guidelines, they will follow them.
That's right.
They want to follow them. It's an innovative industry, and they'll find a way to do it. That's what I believe.
Exactly. And these companies that are operating in the gray, do you think that they're intentionally operating in the gray? I'm sure that there's a flavor of them that are, but is there a flavor of them that maybe just are ignorant to what the rules and regulations are, or potentially they aren't clear enough, like you're saying, black and white? So they think they're doing the right thing. They think they're pushing through valid leads and valid, opportunities, but in reality, they're falling under some of this stuff unbeknownst to their, best efforts.
Yeah, I mean, just from my perspective, what this is a bunch of cars on a freeway that you've never been on before. You don't know what the speed limit is. You're going to drive the same speed as everybody else, right? And that's what happens. They get into this industry, they're looking around, they see what everybody else does, so they do it. Now, the question is, what happens when you see that speed limit sign and it says 65 and you and everybody else is doing 80? Who's the guy out there that then slows down and goes 65, right? That's what we're talking about right now, right?
Yep.
And, again, when I chastised the government earlier, what I was saying is they've never put up a speed limit sign, right? They've never said how many times you can sell a lead, or how many people can be on a form, or how small the font can be, or how big it has to be.
Sure.
They've never put up the sign that said, here's the speed limit, right? So I'm not going to be mad at people in the industry when they're all trying to go faster than everybody else. Like that's entrepreneurship. That's the American commercial spirit. So I'm not mad at them. But now the speed limit sign is going to go up, and now everyone has to abide the speed limit, is kind of my view.
Awesome. Well, I, for one, am excited about what's going to come. I do agree that there's things that are going in the right direction. Maybe there's things that are going sideways or going in the wrong direction. But I do finally feel when this dust settles and everything is, worked through these different industries, I think we're going to have a better environment. I know that's what you stand for, and I think that's what we're all hoping for, right? Because I'm sure everyone who's here viewing this webinar live is dealing with this at some capacity, right? Whether it just be your desk phone that you're picking up to call out and a customer telling you it says scam likely, or not getting the phone call, or the leads that you're bringing into your organization that you're now probably scrambling and questioning right now as Eric is sharing with us what's going on. There's so much to consider. There's so much to look at. There's so many unanswered questions still. I think that, the regulatory agencies are, learning at some capacity as they go, as we all kind of move this forward. So, Eric, if it's right with you, we have about 6 minutes left here. If you want to just take some questions out of the chat, and then we can wrap it up. So, yeah, I want to come back to you, Troy. I kind of botched your question earlier. So if you're still with us and want to clarify it for me, I would like to bring that back up. You said here, and Eric, follow me as I read this one out here. Are you and other defense lawyers still having luck establishing a consent defense for clients who listed hundreds of firms who might be contacting the consumer?
Yeah, so what that question is the FCC came out recently in an order against a carrier and basically said, if you've got 5,000 names on a list, we're not going to enforce that. That list is consent for nobody. Now, that was a very unique situation, though, where it was a multi-vertical consent form, and the company was making calls regarding student loans, and the consent had to do with Medicare. Okay,
Got it.
it was garbage, and the FCC is like, "Get out of here! We're not going to allow you to do that." I believe that in the current legal landscape, now this could change with the NPRM. In the current legal landscape, there is no presumptive limit on the number of partners you can have if they are all within one vertical, and you got an and you limit the number of times that you can sell that lead, right? And you tell the consumer. The classic example would be LendingTree. LendingTree says, we're going to share your information with up to 5 lenders. Now, their list of lenders might be every lender in America. It might be 5,000, right? But that's not a bad thing. That's actually a good thing, because if you think about it, if you're being connected with the best of 5,000 that can meet your needs, that's better for you as a consumer than being connected with the best of 10, right? Presumably, some of that 4,990 you didn't get is going to be better, right? So you want that. Now, that's to be distinguished, obviously, from a situation where you go onto a co-reg site and you're like, yeah, I want that Walmart gift card. And in exchange for that, now you are getting consent to be called by 5,000 different companies on 5,000 different topics, and your lead gets sold 5,000 times, right? That is a very, very different scenario. And I think holistically looking at those two scenarios, the courts and the regulators are pretty smart and know the difference between those two things.
Sure. Thank you for that one, Troy. And then, yeah, Troy, you did bring in here, does Call Tools plan to add human selection feature? And I think this is something, Eric, you were recently covering, and that was in regards to having a human select the order or the sequence in which records are dialed.
You nailed it.
Yeah, so I was recently, like I said, we keep up with what you're talking about out there, and we have an open system here, so we have the ability to integrate and play with different technologies. So it is something we've been considering, and actually one of the first times I was introduced to that concept was through Eric, and I forget the name of the gentleman you brought on, but he was describing his technology that he's developing to have this as a part of outbound dialing campaigns. So yeah, definitely something we are starting to look at, and due to the nature of our platform, it shouldn't be a hard thing for us to adopt in the future. As we continue here, I have another one here from James. Speaking of state laws, can California resident called by a Florida marketer bring suit underneath both TCPA and FTSA?
Yes.
Yes. So that's a direct yes answer for you there, James. And then I have 2 anonymous questions. So people came to 2 questions and answers here. So this is great. Speaking FTSA, can a California resident call by, actually, it's the same question in here again. Oh, here we go. I don't mean TCPA World was claiming, you know what? Let's move. That was the same question. So thank you, James. I don't know why I showed up
James gave it 3 times.
on the other side
right.
over there, but I'm sorry for exposing you if you did want to be anonymous. So I do apologize. I'm just reading through the chat log here. So yeah, we've got about a minute left, and anyone has one burning question, something we inspired in you that we didn't answer during this webinar here, we'd love to hear it. Otherwise, I think we're pretty much ready to wrap it up. Any final comments as we see if anybody else jumps in here, Eric, that you want to leave everyone here with today?
No, I mean, I just want to leave everyone with the message of hope, right? People get very down when they hear these things because things are moving very quickly. And as I told you, it's true, right? The regulators in the states are coming down hard on robocallers, and no one cares to spend 30 seconds to think about the difference between a scam robocall, a spam robocall, and then outbound calls made at high frequency by a call center to consenting consumers, right? And that's very frustrating, and I get that. But the point is that there are regulations out there. You do need to comply with them. You need to take it seriously, and you can, right? And that's ultimately the message. Like, it can be done. I know it sounds overwhelming, it sounds hopeless, but trust me, Pooja and I, right? Like, this is what we do all day long, is we help companies to comply with these laws. And our clients, knock on wood, right? You don't see them in the spotlight, right? So it is possible to comply with these laws. It is hard. It is not easy. And unfortunately, there is a cost component to it. I wish we were cheaper than we are, but we're not. So I get it. And there's other lawyers. It's not just us. but you can't hide your head in the sand here. There is the ability to comply. Believe it, take it seriously, understand you have to do it, and go out there and get yourself some good counsel, and obviously get good information from tcpaworld.com, and rely on good vendors like Call Tools.
Awesome. Thank you so much. And Eric, if somebody wanted to reach out to you or Pooja or anybody at Troutman Amin firm, what would be the best, way to reach out to you guys?
I'm so easy to find. You can just Google TCPA czar. You can go to tcpaworld.com. You can Google Queenie TCPA. You can go to troutmanamin.com, but no one knows how to spell that. So lots of ways. Very easy to find me.
Awesome. You're easy to find at the trade shows too. You got this big sign. You got this big glowing sign, Troutman Amin. It's incredible. So
oh yeah, we have a magazine. You can subscribe to this.
Awesome.
I mean, like we're everywhere, man. We're everywhere.
Awesome. Well, thank you, everybody. I don't see any new questions coming in here. It's been an absolute pleasure to be here with you today. It's a pleasure to be in the presence of greatness with Eric Troutman. Thank you so much for making the time. There was a million things you could have been done, a million places you could have been today. And the team here at Call Tools really appreciate you taking the time to be here with us.
Really happy to be. Thanks, guys.
Awesome. Thank you so much. And if anybody wants to reach out or learn more about Call Tools, you can email me directly, chaz@calltools.com, or just simply visit our website. And thank you guys so much for attending today. It's been an absolute pleasure. Take care.